Good evening, everyone. Welcome to another enlightening session organized by Just Corpus. I am Abhinav Shukla and your host for today's session. And I'm absolutely thrilled to be here with you tonight. Before we begin, let me introduce you to our esteemed guest speaker of the day, Dr. Parineeta Goswami, ma'am. Ma'am is currently working as an assistant professor of law at the University of Petroleum and Energy Studies, Dehradun. She at SRM University, Delhi NCR, and then moved to Manipal University, Jaipur. Before teaching roles, she worked as a research fellow at the Rajiv Gandhi National University of Law, Patiala, Punjab, from August 2018 to October 2021. Her primary areas of interest lie in banking laws, insurance laws, arbitration laws, corporate law, mergers and acquisitions, insolvency and bankruptcy law, among others. Her educational journey began with a BCom degree from the International College for Girls, Jaipur in 2011. She completed her bachelor's in law from University of Rajasthan in 2014. Later, she pursued LLM from Amity University, Noida, specializing in corporate banking and insurance law, where she held the second position and the prestigious Sri um, Baljit Sastry Award for Best in Human and Traditional Values at Amity University in 2017. In June 2018, she cleared the UGC NET examination and obtained the Junior Research Fellow and Lecturership. She has completed her PhD in law at Arjun this year. She has two books on her name and published numerous papers in reputed Scopus, UGC Care Listed, and peer-reviewed journals, and has also presented papers at different national and international seminars and conferences. She chaired various national legal events, ADR competitions, moot court competition, etc. To our esteemed guest, thank you for joining us. We are honored to have you here, ma'am, tonight.
Thank you,
Now,
Abhinav,
before we dive
for
into our
such.
topic,
Yes, please.
welcome, ma'am. Uh, Now, before we dive into our topic, let me give our viewers a brief overview of the organizers behind tonight's session. Just Corpus is a body of legal professionals who have brought various aspects and chains of law under a single umbrella. Just Corpus, an edtech platform established in 2020, has a wide reach of 600,000 clicks per month on an average basis on its website. The inspiration was derived from the growing need for law students. Just Corpus has also incorporated an interdisciplinary journal as its subsidiary named Just Corpus Law Journal. Now, on to the main event. This evening, our esteemed guest will be shedding light on the topic on complexities of the Insolvency and Bankruptcy Code, challenges and opportunities. Ma'am, I welcome you once again. The virtual stage is yours.
Thank you so much. I believe everyone is here. Mostly the students are here to learn something about the Insolvency and Bankruptcy Code, the mostly issues and challenges. But before we dive into the main topic of issues and challenges, first we must be knowing about the what is this code, what we are talking about. So let me start with a little bit intro of this code, the objective, then we will dive into the main problems this code is still facing. So the Parliament of India enacted this Insolvency and Bankruptcy Code 2016 and received the assent of the President on 28 May 2016. It was implemented to provide time-bound resolution to entities facing financial distress. This code was enacted with the object of saving distressed entities by providing a resolution of insolvency. It is a game changing legislation that has been enacted to consolidate the law relating to insolvency and bankruptcy, which was here though scattered in various laws, and also to provide time bound resolution to the debtor who is in the state of insolvency, and at the same time provide quick remedies to all the creditors and employees. So since the date of enactment of this code, we have come a long way. We have done so many amendments multiple times. During this whole 6 periods or more than 6 periods, the code has been amended as many as 6 times by the legislature. Further, the main regulator of this code, the Insolvency and Bankruptcy Board of India, has made as many as 84 amendments to 18 regulations made under this code. And if I counted now, I can see the data that out of these 84 amendments, 22 amendments have been made during the period of 1 year ending September 22. That is after the COVID. So this code seeks to deal with the evil of non-performing assets which have been plaguing the Indian economy. And thus it has immense ramifications for the economy. So the impact of the code can be gauged from the fact that the resolution of 12 large accounts, which are initiated by the banks on the direction of RBI, involved an outstanding amount of rupees 3.45 lakh crore. So we can say that this code is a very important legislation. Before this enactment of code, we have a laws relating to insolvency and bankruptcy, but they are all scattered in various enactments. For example, we have Companies Act 2013, we have a Recovery Act 1993, we have a Securitization Act 2002, we have a SICA Act 1985, we have a Presidential Insolvency Act 1909, Provincial Insolvency Act 1920. All these acts are there, but some of them deal with the corporation and only 2 acts deal with the problems of the individual. There are so many laws, so the multiplicity of law resulted in multiple authorities, overlapping provisions, multiplicity of legal proceeding before different forums, and numerous delays in debt restructuring and liquidation. Also, the corporate debtors seeking protection under SICA provision to avoid recovery, and they have a loophole in the SICA Act also, reduction in the value of assets and net worth of the business. So not only the previous system relating to insolvency and bankruptcy was scattered, but also the law was inadequate. I can say that. And it's unsuccessful, causing numerous delays in the insolvency resolution. So the government has enacted this code. But this code has so many lacunas, and we are going to discuss all these code. Before that, we must know what will be the objectives of this code. So the main objective of this code is to consolidate and amend laws relating to reorganization and insolvency resolution, to provide a time-bound resolution of insolvency, to ensure the maximization of asset value, to promote entrepreneur in society, to ensure an increase in the availability of credit in the market, to balance the interest of all the stakeholders, to establish a regulatory body, to provide a comprehensive procedure for insolvencies related matters. So this code paved his way for the establishment of an apex body for supervision, for control and regulation of insolvency and bankruptcy in India. That is Insolvency and Bankruptcy Board of India. So the board is the most important institution in this new design for the implementation of the code. Board is the highest body in this whole institutional framework for insolvency resolution and bankruptcy. It is responsible for overall supervision and control of the institutional mechanism. It also lays down all the rules and enactments, regulation for the smooth implementation of the code. They also regulate and controls the insolvency professional agencies. They provide the process to resolve the problem of non-performing assets. So the regulatory mechanism which is laid down under this code has the main 5 pillars. That is Insolvency Bankruptcy Board of India, insolvency professional agencies, insolvency professionals, information utilities, and last not least, the adjudicating authorities. Now the question arises, who can file a case in insolvency for the insolvency? So the code provides that insolvency proceeding can be initiated when the entity commits a default. default in payment of minimum prescribed amount. So to initiate the insolvency procedure, the minimum default amount is provided for different types of entities. So for the corporate debtors, the minimum default amount is 1 crore. For partnership, the minimum default amount is 1,000, and that can be more up to the 1 lakh. And for micro MSME, the minimum default amount is 10 lakh. So once this default is committed, the financial creditors, the operational creditors, or the debtor itself can file an application of insolvency resolution process before the adjudicating authority. So the important change brought by the code is from debtor in possession to the creditor in possession. So once the insolvency is triggered, that is when a default of prescribed amount is committed, that creditor can move an application for initiation of CIRP. And once this application is admitted, the control of business of debtor is shifted from the hands of debtor to the creditors. And now the creditors become eligible to make major decisions regarding the business. So this all thing is called that code contemplates the formulation of committee of creditors, which includes all the financial creditors. All decisions taken by this committee of creditors. They will appoint the interim resolution professional. The interim resolution professional plays a very important role. They are after the approval from the adjudicating authority, and he takes over the charge of the business from the debtor. So the whole these procedure will be completed must be within 180 days, and the 90 days extension will be given if the adjudicating authority is satisfied. Now, this is the basic part of the code that they have. This is code mein kya hai, kab aaya, what is the 5 pillars of the code. All these are the cover. Now, what is the problem? The main topic which are we going to cover, the challenges to the smooth implementation of this code. So IBC has provided a comprehensive framework for dealing with insolvency in a time-bound manner. The present system still is not free from the defects. We have pop up with so many issues, which we are going to now discuss. First one, that is time-bound resolution of insolvency. The main object, we have learned the objective of the code, that the main object is the time resolution. Section 12 of the code provides the time frame to complete whole corporate insolvency resolution procedure after the admission of the application, that is 180 days. Only one time extension of 90 days can be given by the adjudicating authority, which must be approved by the committee of creditors. And that is the voting on need required 75% votes. Also, civil courts have no jurisdiction to grant extension or injunction, as they can be gathered from section 63 or section 64 subsection 2 of the code. So the NCLT can also extend at the time according to Rule 15 and Rule 115 of the NCLT rules. However, there are a few issues regarding the time frame which is provided under Section 12 of this code. The question is required to be answered is under what circumstances the NCLT can extend the time limit, which is specified in this section number 12. And also, it is very necessary to expedient to examine some judicial decision when which the time extension is given. For example, the case, if you want to write down, you can write down the case, that is JK Jute Mill Company Limited versus Surendra Trading Company. They said that time is the essence of the code. So the whole procedure must be completed within the time. Extension of the time will be given by the authority, adjudicating authority, only in special circumstances and not in routine. Apart from the overall timeline, there are time frames for completion of various process. For example, code provides the NCLT that they have to admit or reject the application within initiation of CIRP in 14 days. The question is whether this time frame is mandatory or directory. If the decision given by the NCLT in this case that the 14 days for admission or rejection of the application by the NCLT is directory in nature, So the NCLT can extend the time limit on a case-to-case basis in the interest of fairness and justice. So Supreme Court in appeal ruled out that 14 days time for accepting or rejecting the application for initiation of CIRP is directory. Court has said that it is a well settled principle of law that where a statutory functionary is asked to perform a statutory duty within the time prescribed, therefore the same would be directory and not mandatory. Now, this question is answered by the Supreme Court like that. Now we have another question regarding the timeline and its extension, which is considered by the NCLAT in the case of Quantum Limited versus Indus Finance Corporation Limited. That whether the application for an extension of the period for completion of whole procedure is required to be submitted within 180 days of completion of procedure, or it can be submitted later. So in this case, the application filed after the expiry of 180 days. So NCLT has rejected the application. However, when the appeal has gone to the NCLAT, they said that since an extension of 90 days can be granted only when the same is approved by the committee of creditors by majority of votes, 75%, then this application may get delayed. Now, same thing happened in this R steel case. So, extension granted by NCLT and NCLAT led to non-adhere of the overall time limit of 270 days. That is 180 days plus 90 days. So, Supreme Court again in the case of Macquarie Bank versus Shilpa Cable Technology said that a litigation period must be included in whole time period for the procedure. So now, if we interpret the code is saying that the limitation also that the time used in legal proceeding must be excluded from the consideration of time limit of 180 days. Now the question arises, what are the circumstances in which the time can be excluded? Are these circumstances are for exclusion of the time as inferred from the legal provisions or the judicial decision? For example, can the CIRP be stopped by the court, NCLT, NCLAT, or Supreme Court if the resolution professional is not functioning during the CIRP? When the resolution professional takes charges of corporate data affairs after the expiry of prescribed period? So all these questions are still kept in mind, and we have stuck in the point of therefore it is important to resolve insolvency within the resolution stipulated time period. Now we have a most prominent example is a SAR steel case. There are so much amount is involved in this case. In this case, around 50,000 crore was stuck for more than 600 days in the whole procedure. The foregoing discussion bring the point that time limits provided under the code are not sacrosanct, and in appropriate cases they can be extended. So it is upon the case to case the time limit is they are agreeing with the time limit or they are not agreeing with the time limit. So this is the main problem of the code, that they are not giving the resolution which is as per the time period. Now the another issue which is code is facing, that is the working of the committee of creditors. The financial creditors play a central role in the whole insolvency resolution procedure. So, and the key objective of the code is to resolve the massive non-performing assets numbers that frightens the book of India banking sector. Therefore, financial creditor will occupy a very important place in the entire process. But there are a variety of complications created by financial creditors, like the consortiums of banks. The representatives sent by the banks during this committee of creditors meetings are not given adequate authority to take decisions during the meetings. Decisions are taken later by the competent authorities of the bank. So this undermines the conduct of the committee of creditors meeting, as the resolution professionals only inform the members of the progress of the corporate insolvency resolution procedure, and the decisions are later taken, which consumes a lot of time. This adversely affects the whole process. including all the important decisions, whether to keep the debtor business alive by continuing the business of the entity, or whether we have to go for the liquidation, whether we have to accept the resolution plan or not. So, interestingly, there is no code of conduct for the working of such important functionary in the whole procedure. IBBI has proposed a code of conduct, but yet it has not been put in place to date. So there is a very much need to formulate and implementing a code of conduct for the committee of creditors to ensure transparency in their decision, which is making and reasoned decision making. Third problem, voting and e-voting in the committee of creditors. Just a minute. As I said earlier, the most important cog in the wheel of the code is the committee of creditors. They consist of only financial creditors and they make all the decisions relating to the corporate insolvency process. So the code initially, if decisions shall be taken by the majority of the financial creditors voting, that is 75%. This was at par with the corporate debt restructuring mechanism, where in 75% of the bankers approve a restructuring plan that is binding on all the lenders. Now an amendment was made in the code and the threshold voting share was reduced to 66%, owing to the response from the various quarters. So in certain other matters, the voting threshold was specified as 51%, 66%, 99, 90%, etc. It may be relevant to state here that the voting by the committee of creditors member can take place either in physical mode or through electric voting. So the provisions containing e-votings are governed by the Regulation 25 and Regulation 26. Now, this provision relating to e-voting has now undergone an amendment, which provides that the resolution professional shall pursue a vote of the members who did not vote on the matters which were listed for voting at the meeting. So the voting will be done through the electronic voting system according to the Regulation 26. Before this amendment, the Regulation 25 provided that if all the members are not present at a meeting, voting shall not be conducted, and the voting can be take place through an e-voting system. But after the meeting of the committee of creditors, wherein voting has taken place, the resolution profession is required to circulate the whole minutes of the meeting within 48 hours and seek a vote on the matters listed for voting in the minute by an electronic voting system, giving another opportunity to those who did not even vote, even though they were present in the meeting. So this said amendment, which is done in Regulation 25, open a situation where the members present in the committee of creditors meeting but not taking part in the voting process will have another opportunity to vote by e-voting process, thanks to the words who did not vote at the meeting, which is amended in the Regulation 25. So the financial creditors, particularly bankers, have a hierarchy in their management, and therefore they seek their higher authority approval before deciding by themselves. So now they have a very handy tool to skip voting to the committee of creditors meeting and later vote through the e-voting process. So in this team, the members of the committee of creditors they have a very important responsibility on their shoulders that which will decide the fate of the corporate debtor. So court has bestowed very important power to their shoulders, very responsibility. So they have to done some right perspective and make appropriate decision promptly. So I can say that it is the voting should take place in the meeting itself if the decisions were to be taken quickly as per the requirement of a court for a time-bound resolution. So the e-voting should be resorted to only when the required percentage of voting threshold could not be achieved with the voting of the members present in the meetings. And the voting share of persons who were not present in the meeting would be critical to reach the threshold and pass the resolution. That is my suggestion. The fourth problem that I can see is the order of priority. The priority of charges and priority of distribution or proceed referred to as the waterfall mechanism. It has also so many defects. The code had identified the order of priority according to which assets will be distributed during liquidation. But this order of priority raises many questions, such as why the secured creditors will get the whole outstanding amount and not up to the collateral value. Another question is why trade creditors are below priority in comparison to unsecured creditors. Another question that why the government dues are in the last at the order of priority. So I observed that the first charge holders do not wish to share the proceeds of the asset with the second charge holders. So this waterfall mechanism is a very tedious matter. Many times the entire decision making, that is approval to avoid liquidation, depends on it. So the due to the order of priority, the operational creditors resort to the litigation because generally they get a very low percentage of outstanding dues in this resolution plan. So this is the fourth problem. Now the fifth problem is the challenges faced by the resolution professional. The resolution professionals are a very important linchpin in the insolvency resolution regime. During a corporate insolvency resolution process, the resolution professionals have various responsibilities, such as taking over the management of corporate data as the representative of creditors, keeping the operation running as ongoing concerns, identifying the transaction of a fraudulent nature, ensuring variance compliances of several regulatory authorities. The list is endless. So, insolvency professionals are the backbone of the whole code. They manage the affairs of the distressed business entity, manage, follow up the committee of creditors and resolution applicant, prepare and submit several reports. So they are accountable for their action to the committee of creditors and adjudicating authority. So to ensure that the best professionals are available, the board prescribe an examination which is based on the UK and Canadian models for the registration as insolvency professional. The first batch of insolvency professional was appointed based on their qualification only because at the time of infrastructure we can say that for conducting the examination was not available. So the board is required to ensure that the insolvency professionals are enrolled after following the due process of examination and filtration. There is another issue regarding the insolvency professional, the problem faced by them during the whole procedure. The obstacles faced by this group daily are innumerable. Though they have come forward to rescue the professionals have come forward to rescue the system. They are being made the victim and are the worst sufferers in the process. The challenges range from no ratification of even the payments made from their pockets for the smooth operation of the whole procedure of the corporate data, leaving aside their remuneration and going to the extent of the threat of litigation, which is filed against them. So committee of creditors do not even provide the amount of insurance which is necessity for the preservation of assets. So while performing their duties, resolution professionals often come up with various issues which include blackmail, fabricated complaints from various stakeholders such as factory workmen, promoter groups, prosecution threat by various authorities such as income tax for not filing returns even for the earlier years, lack of immunity against false FIR filed by such stakeholder, hostile behavior from existing employees while they are extracting the information. So during this whole procedure, resolution professional has to struggle to receive information and to recover documents from the earlier management to complete the compliance of the code. So therefore, it is required that a conical atmosphere for the working of the resolution professional be created to ensure the smooth functioning of the code and revival of the business entity. Now, another issue is infrastructural issue. This is the one of the reason of tardy implementation of the code is the lack of infrastructure for the adjudicating authority and the appellant authority. This is the one of the reason for the increase in the number of pending cases. An expansion of infrastructure and human resources is a must to keep the process running smoothly. The successful implementation of this dynamic time-bound legislation requires increased number of benches or mechanisms to reduce the load on the tribunals, which currently get over-involved in various stages of the corporate insolvency resolution process, rather than they are operate to ensure timely approval of the resolution plans. If I go by the data which is available on IBB website, in July 2020 only, 19,844 cases were pending before NCLT. And only 52% of cases were closed till September 2020. It is therefore apparent that not only administrative delay and approach of the adjudicating and appellant authority, but also the lack of an appropriate number of benches and the infrastructures are the major reasons for the slower resolution process. So it is very much necessary as the NC, we have to encourage to establishment of more NCLT benches because they have to handle the cases under IBC, the Companies Act, cases under the BIFR, and some cases of DRT also. So this is very much necessary to enhance the capacity of NCLT to ensure the prompt disposal of cases. Now, the another problem is the regulation of cross-border insolvency. This is what is the cross-border insolvency? Let me explain. Then the debtor or creditors who have financially distressed asset in more than one country are subject of cross-border insolvency, or we can say that international insolvency. Owing to the expansion of international investments, cases related to cross-border insolvency have seen an increase in contemporary times. Regulation of cross-border insolvency is a complicated matter which involves several jurisdictions, several distinct laws, and multiple forums. Court and legislature of different jurisdictions provide different solutions to various questions that arise in cross-border insolvency. The problem relating to cross-border insolvency is not confined only to the failure of international business. It may also include domestic business, which may have any foreign branches or subsidiaries, and foreign businesses, which may have any domestic branches or subsidiaries. So insolvency issues also arise when foreign creditors have a valid claim in a domestic bankruptcy case and domestic creditors have a valid claim in a foreign bankruptcy case. So in India, laws related to insolvency are not well equipped to deal with the international insolvency cases. The one of the issue is the fraud done by the insolvent debtors by transferring their asset to a foreign jurisdiction. Also, the coordination between the court and administrators of various countries is lacking. Another issue is related to bilateral treaties. So these multiple treaties provide a non-uniform approach to the insolvency resolution process. These problems show that the inadequate and uncoordinated legal approach to the cross-border insolvency. The present approach lacks transparency and does not have the necessary tools to address these issues. These absence of predictability in cross-border insolvency cases adversely affect cross-border investment. These problems need to be urgently addressed. If Indian law does not get recognition in overseas jurisdiction or international law does not recognition in India, then it will create a challenge for all of us. Now, another problem is the problem faced by the resolution applicants. They are the real rescuers of the court. They are the indispensable units of the process. They bring in the money and the method to cast out the non-performing assets accounts from the books. They provide the structure through which the primary objective of the court, that is reviving sick companies, can be achieved. However, the resolution applicants are also vulnerable to many challenges. The challenges begin with the presentation of them before the committee of creditors. where they are grilled, interrogated by the committee of creditors, and not embraced as they should be. Further, any potential acquirer of a business would require that it take over the debtor free from all encumbrances and charges and would pay for the waiver of past contingent liabilities and obligation as complete reasonable necessity. But in most of the cases, the same has been disapproved by the creditors or the NCLT. They are expected to take over the asset and business as on as is where is basis with all attachment and encumbrances. The law itself need to be modified to effect that once a corporate debtor is under the code, all the attachments and contingent liabilities of past business should be clear to seek an effective resolution. So the industry need to realize that the opportunity on both sides of the table. Not only do they provide recovery for the creditors from the distressed asset, but there is also indication of potential revival of a dead company. And for investors, it is an easier channel of business development through expansion, growth, diversification of existing business. They also help the employees by keep the business and jobs alive. So must we have to do something for that. Now, there is another problem which is faced by the information professional agencies. They are the supreme body for the regulation, supervision, and monitoring of the insolvency and bankruptcy in the board. The board regulates the whole insolvency professional agencies. But there are multiple regulators. For example, chartered accountant chapter, company secretary chapter, different types of insolvency professionals are there. So the presence of multiple insolvency professional agencies create unhealthy competition on market, which create unnecessary conflict between the regulatory bodies of the insolvency professional agency. Now, the last problem which we are going to discuss is regarding the information utility. The information utility act as a repository of the financial information. The main aim of the establishing information utility was to remove information asymmetry under the whole code. So as per the scheme of the code, an information utility can quicken the procedure of insolvency by providing access to the evidence of the default. So it is required to facilitate the information about the formation of committee of creditor within 14 days of registration of case. So it is worth pointing out that the cost of repetition, that the corporate insolvency resolution process is a time-bound process, and role of every functioning including information utility is very important to meet the deadline. Also, it is relevant to note that the whole procedure is not completed within stipulated time period. The adjudicating authority can order liquidation or the winding up of the business. So it is very utmost importance that the information utility collect this information and provide the relevant information. However, pursual of information available with the board revealed that to date only one information utility has been registered with the board. So we need to have a more information utility to meet the goal of the code. Further, corporate debtors and creditors appear to have a trust deficit regarding the creditability of the information utility. So we need to trust the system so that we can work as per according to that. So these are all the issues which we are facing in the code, whether it's relating to insolvency professional agencies, information utility, infrastructure problems, all these problems which I saw on a broader aspects are facing by the insolvency bankruptcy code. That's it from my side. Thank you. If anybody have questions, they can ask me.
Thank you so much, ma'am, for such an informative session. Now we will move to question and answer round. Uh, Now, when the first question that I have received is, what is insolvency resolution process period? Which I've already explained, but since I have got this question, I'm asking that.
Okay, the period is 180 days, and one time extension will be given, that is 90 days. So it will be included 270 days. But after the amendments, now the whole period's time period will be the 330 days, that is 270 plus 90 days extension.
Ma'am, the second question that I have with me, the CIRP process is complex and time consuming. IBC's provisions regarding the inclusion of subsidiary assets in the CIRP of a holding company is explicitly clear now. Do you think that the CIRP process is in interest of various stakeholders, including creditors, shareholder, and employees?
Yes, I
Now
think
it has,
so that they have taken. Okay, continue.
ma'am, no, you can continue.
Okay, okay. Yes, I think that this CIRP procedure is fruitful. But besides, I have mentioned the 8 or 9 lacunas in the code, but still the code is working very good, I believe. So initial stages are going on. They are making so many amendments, but they have taken care of all the stakeholders in their mind. The procedure is from now data to creditors control. Fight between financial creditors and operation creditors will be going on, and it's never ending, who will be get more money. But if I see that the why the financial creditors are more important, because they have invest more amount also. So they have taken care of the each and every aspect, but there are some small basic problems that they are still facing, which they are going to resolve in the due time course.
Thank you so much, ma'am, for the answer. Then the third question is, how can technology streamline insolvency proceedings?
That is a very good question, but I think it will take time to include the technology in this case. But we have some little bit, not technology, but a procedure. It's a fast track insolvency procedure, which is 90 days. The case will be solved, and this is the all the documents and evidence will be done on the online platform, and there is nothing extra time will be given on this. But the technology which is using now in the cases of arbitration, which will also can be, we have a portal that we can track the application, can be done in due course of time. But that all depend on the insolvency bankruptcy board. But it can be helpful to track the application basically.
Thank you so much, ma'am. In fact, my next question was on the same topic of fast track insolvency resolution process. So, anyways, I will ask you for a detailed explanation on the same. That what are the key differences between fast track corporate insolvency process and regular CIRP
The
under the IBC?
Yes, basic difference between the timeline. The fast track timeline is the 90 days, and 45 days extension will be given by the adjudicating authority. The basic this, apart from that, the documents, the extra things which is done in the procedure only, that can be skipped in this part, then they can be later submitted, or they can submit it by, and the procedure is still going on. It is the according to the both the teams, if they are ready to, then they will go for the fast track insolvency procedure. Am I audible?
Thank you. Ma'am, so, ma'am, like, what is the scope of work the professional? What are the career options in insolvency law? As how should proceed this as a career option?
Very good option. Nowadays, I believe so. Everyone should be work on the insolvency right now. From after the graduation, whenever I teach my students, I say that you are one of the person who can become the insolvency professional. So do register yourself in the C or CS chapter, or do involve in the cases related to insolvency and bankruptcy. In near upcoming 5 or 6 years, the more earning person will be the insolvency professionals only. So that is a very good career plan, whether in the case of academician, litigations, or a professional space. It's in a boom in the market right now. I heard that is the way.
Thank you, ma'am. I think many of us will be forward to the insolvency as a career option after informative session. The next question that I have, that is, what are the fundamentals we should be aware of these concepts like bankruptcy, insolvency, and what are the study materials or any platform that we should regularly follow to keep an update on the insolvency law and FID?
Okay. So, though I think this is a question asked by the some students. First, you have to know the meaning of insolvency, bankruptcy, and liquidation. Difference between these three. Then the five pillars of the IBC, that is Insolvency Bankruptcy Board of India, Information Utility, Insolvency Professional Agencies, and Adjudicating Authority. ये पांच चीजें पढ़ो, तीनों का मतलब पढ़ो, होल प्रोसीजर का एक फ्लो चार्ट है वो पढ़ो. अपार्ट फ्रॉम दैट वहां कहाँ से स्टडी मटेरियल मिलेगा? काइंडली गो थ्रू द इंसॉल्वेंसी बैंक्रप्सी बोर्ड ऑफ इंडिया वेबसाइट. दे आर वेरी पर्टिकुलर. सारे अमेंडमेंट उनके अच्छे से अपडेट होते रहते हैं. नोटिस, सर्कुलर, कोड, हर चीज उसमें है. उनकी एनुअल रिपोर्ट आती है, केस डाइजेस्ट आता है. दैट इज वेरी गुड. फॉर द बुक्स यू कैन रेफर द अकांत मित्तल की बुक्स अच्छी हैं, सुमन बत्रा की बुक्स अच्छी हैं. होपफुली नेक्स्ट ईयर मेरी बुक्स भी आ जाएंगी, सो यू कैन रीड दैट बुक्स ऑल्सो. सो दीज आर द गुड मटेरियल्स.
Thank you so much, ma'am. We as a group will definitely go through the sources and the ways that you have suggested us. And we will also be looking forward to your book as well and to get your perspective on the law. Uh, I think that's all, ma'am, in the question and answer round. Thank you so
Oh,
much once again for providing such insightful perspective on these complex issues. Uh, and with that, we concluded another illuminating session brought to you by Just Corpus. A big thank you to you, ma'am, for sharing your expertise with us tonight. And we will welcome you once again in the next seminars if we organize.
thank you for the opportunity. Thank you for hosting the session, Abhinav. And best of luck all the students for listening me for 1 hour. Now you can have a dinner with easily. Thank you, everyone.